Civil procedure, discovery. Discovery is an important part of the US legal process. Opposing parties are required to share relevant evidence and information. This often leads to settlement of the case after each party has had opportunity to review the evidence and assess the other side's argument. Discovery is handled by opposing attorneys in the United States, not the court. Some categories of information required disclosures, such as the name, addresses, and phone numbers of all witnesses and discoverable information that will likely be used in the case, must be provided to the other side, even when it's not being requested. Some requests, such as requests for physical or mental examinations, require prior court order. Although anything relevant is potentially subject to discovery requests, there are exceptions for information protected by the client-attorney privilege and other privileged relationships such as communications between husband and wife, doctor and patient. Privileges apply to state secrets, trade secrets, and certain official information. Any non-privileged information relevant to a claim or defense is discoverable. This is now narrower than the old rule that allowed anything relevant to the whole case. Now the information has to be relevant to a claim or defense by any party. What is relevant is information reasonably calculated to lead to admissible evidence. This is broader than what is actually admissible in court. Not counting the automatic or required disclosures, there are 5 methods of discovery available to the parties. Some methods can be used to gather information from parties only, and some methods are available to gather information from non-parties, such as witnesses. Depositions are oral answers to questions that are usually recorded and written into transcripts. The questions can be posed in writing or orally. Witnesses and other non-parties can be required to provide depositions by subpoena. Subpoena is not required when deposing parties. Motions or requests for production or inspection of documents can also be made to witnesses and non-parties by subpoena. Subpoena is not required when requesting these documents from a plaintiff or defendant. Witnesses and non-parties are protected and excluded from the other 3 methods of discovery. A party, by court order, can be required to submit to physical or mental examinations. Clearly, it would not be fair to ask this of a witness. This is an area that has potential for abuse. Examinations by a doctor must be approved by the court and demanded under court order. It would not make sense to ask a witness or non-party to admit the truth of a claim or fact, and admissions are only available against parties to the case. Interrogations are questions and answers in writing made under oath. With subpoena, a witness can be required to answer questions orally in deposition, but cannot be required to answer interrogatories in writing. These 5 methods of discovery enable each side in a case to gather documents, recordings, reports and answers they need to prepare for trial. Experts are often highly influential witnesses at trial. The name and addresses of experts, together with copies of the experts' written reports, are required disclosures and must be provided to the opposing party, whether they are requested or not. Also, the opposing party, by request, can depose any expert whose opinion may be presented at trial. This applies to experts that are retained and may give evidence at trial. If the expert is retained to advise a party, but not to give evidence at trial, his advice and opinions are not discoverable by the other side. The discovery principle in the United States opens up the possibility of a party burying the other side with a request for documents and information that's unnecessary and intended merely to distract and waste valuable time. So US courts look for assurances that the discovery requests are warranted are not for improper purpose and not unduly burdensome. These assurances are not provided under Federal Rule 11, as this applies only to pleadings, papers that are filed with the court, not papers provided to other parties. Requests for discovery materials must be signed by the attorney certifying the request is warranted, not unduly burdensome, and not for an improper purpose. Answers provided by the parties must be signed and certified by the attorneys and the parties under oath. Discovery does not extend to materials prepared in anticipation of litigation. It would be unfair to force a party to disclose its strategies for winning the case to the opposing side. It would be like forcing a chess player to disclose his strategy before the game. Work product provides a privilege to mental impressions and legal strategies formed under the client-attorney relationship. But it's not limited to materials prepared by a lawyer. The client's own pre-trial strategies and those of other advisors are also work product when prepared in anticipation of litigation. There are exceptions where the party demanding the information from the other side is able to show substantial need for information that it cannot otherwise obtain. When a party requested to produce information fails to produce, after certifying in good faith that attempts were made to gather the information requested, the opposing party can request a sanction from the court. The court then has three options: no sanctions, light sanctions, or heavy sanctions, depending on the seriousness of the violation. If the information requested is unduly burdensome or subject to privilege, the court can grant a protective order preventing its disclosure. If no protective order is made, and some but not all the information requested is delivered, the court can sanction with a court order demanding the delivery of the outstanding materials, and the sanctioned party can be asked to pay for the costs of bringing this motion. The most serious sanctions are reserved for situations where none of the information requested was delivered or where a court order demanding the delivery was disobeyed. These sanctions include dismissal of the case where bad faith is found, charges of contempt of court, fines, striking of pleadings, disallowed evidence, as well as court orders and costs. A case can be adjudged and dismissed based on review of the complaint. There's no point in holding a trial if it's impossible for the plaintiff to win a judgment. If the claims in the complaint do not warrant a remedy by the court, the case can be dismissed under Federal Rule 12b-6 for failure to state a claim upon which relief can be granted. The court assesses the sufficiency of the claim, does not assess the evidence, and then determines if there's any possibility that the plaintiff can win a judgment. The judge assumes all the allegations made by the plaintiff are true, and dismisses the case if the complaint fails to state a claim on which relief can be granted by the court. The dispute can sometimes be decided based on a review of the evidence presented by each side. If there is no dispute over the facts, the judge is in position to decide the case. Either the defendant or the plaintiff has a right to bring a motion for summary judgment under Federal Rule 56. The judge reviews the law and the evidence of the facts in the case. The evidence is often provided as affidavits, sworn statements. The evidence must be admissible. Inadmissible evidence such as hearsay cannot be considered. If there's no genuine dispute over a material fact, the judgment can be made as a matter of law. Motions for summary judgment are very popular with the parties. They appear in almost all federal court cases. But summary judgments are not very popular with the appeals court, as they have to review summary judgments de novo. The judge can order attorneys and unrepresented parties to attend one or more pre-trial conferences. Attendance is mandatory. The pre-trial conference is designed to expedite the judicial process, create a blueprint of the trial, and facilitate settlement. The blueprint is created in the form of a pretrial conference order that identifies all the issues and the evidence. This assures there are no surprises at trial. An issue that's not listed in the pretrial conference order cannot be raised at trial. A witness not listed in the pretrial conference order cannot testify at trial.